Hello, everyone. I'm Margaret Martens, Executive Director of the Water Systems Council. And we are here today to talk to you about what is going on in Washington, D.C. these days. Lots of exciting things for the water well industry, and also to give you a legal update as to the things affecting our industry right now and in the future. So in order for us to do that, I have two very important people for us along with me. We have Jeff Moore, our government affairs liaison, and Jesse Richardson, our legal advisor, here to update everybody on legislative and legal issues facing the water well industry. So Jeff, we've had a wonderful, huge infrastructure bill passed recently. Tell us about it.
Yes, it's exciting, and not to surprise anyone, it probably will be the most significant and maybe the last major thing that gets done in this Congress. Gridlock is back in full display. So we should be real happy that a $1.2 trillion infrastructure bill was signed into law by President Biden on November 15th. And, it came out of the Senate with 69 votes, including 19 Republicans, including Mitch McConnell as supporters. Legislation that was crafted the right way. The Water Systems Council from, this time last year was very engaged with the House and Senate committees of jurisdiction, the Environment and Public Works Committee in the Senate, and the House Energy and Commerce and Transportation and Infrastructure Committees. And it was really water infrastructure funding that passed the Senate with overwhelming bipartisan support. It was the first major thing that was done in this Congress. And we really believe that we were a big part of getting them to a much larger $1.2 trillion bill. Drilling down in this historic bill, historic funding for both clean water and drinking water infrastructure, direct funding over the next 5 years of $55 billion, and that's going to be matched by states. There's also the WIFI Program, which the Water Systems Council was very instrumental in getting put into law originally and included in here. And the $50 million a year that's put into that will leverage about $5 billion for water and wastewater infrastructure, was included at our recommendation. They also included language that made clear that the WIFI program was to include small communities and small systems that are particularly disadvantaged and often dependent on wells or are in a position to utilize wells. The bill really changed the focus of the Safe Drinking Water Act in ways that are going to be really important to our industry going forward. Small disadvantaged communities were given top priority in this legislation. The Safe Drinking Water Act state revolving fund monies will see a 300% increase. We're going to go from 1.1 billion a year to almost 4 billion. And that money, again, will be matched by the states. And then that focus for that will be on small and disadvantaged communities as the top recipients. The Safe Drinking Water Act, as you'll hear in great length probably from Jesse later on, is a health-based statute which poses a lot of unique challenges but opportunities. And some of the real significant challenges are for small communities, the ones that we work with, communities 500 or less often. And the bill really makes that a priority for these new state revolving fund dollars. It also requires the states to send out that money. The state revolving loan program was a loan program. And if you're a community of 300, you're never going to have the rate base to do a major upgrade of your drinking water or ever deal with a lot of your issues. What this does is make 49% of that money go out in the form of grants, basically. And that's going to allow a lot of folks who, small community, half their population is way outside of town. They've never run water out to them. The cost-effective way to do that for a lot of these is going to be to do wells and well systems, cluster wells to bring water to these folks. And they'll now have an opportunity to participate in these programs. There is an intended use plan in the state drinking water system where they list projects. And a lot of the projects that we're focused on really never got the funding they should get. And that's going to change dramatically over the next 5 years. They put in $510 million explicitly for small and disadvantaged communities. And they really understood that individual wells were part of that. In fact, for the first time, they've made this funding available for point of use and point of entry filtration. I'm going to talk a little later about PFAS and other drinking water challenges out there. And this is a huge, important investment so that if folks we want to keep faith in groundwater, and this is going to allow for folks to treat the water with assistance from the government, as their well comes into their house, which is just a great thing for us. Turning to the PFAS, they're going to invest hundreds of millions of dollars in trying to get a handle on where it is, where homes, where water supplies are impacted. And fear about this is one of the things that will drive people to hook up to a municipal system. The reality is that groundwater and surface water all have PFAS contaminants. And having a sound knowledge base here is going to help people trust their well water and stay on wells. So I think that's really an excellent development for us. And there are thousands of chemicals that fall into this PFAS category ultimately, and the regulation of those is going to be, I think, quite a ways out for a lot of things. And we need to keep people believing and understanding that the quality of their drinking water is safe. The other big things they did were include funding for under the Clean Water Act title. They included $250 million to help with septic systems, with individual wastewater, treatment. And again, with every septic system usually comes a well. And if we want to keep people using wells, this is a really important part of the equation. Poorly working septic systems contaminate both surface water and have implications for groundwater quality. And this is a historic investment. They've never made federal money available for individual septics before. And this is really an important part of the equation. You can do the math, if we were to give homeowners $1,000, you're looking at 250,000 homes that could be recipients of assistance for their septics. So that's really a great opportunity as well. With all this new money, in the past, the Water Systems Council has been successful in getting the Water Supply Cost Savings Act into law, which requires any community of 500 or less seeking a grant or loan to do a drinking water project to self-certify that they looked at wells and well systems as part of the solution. And with this new funding, there's going to be a lot more small communities who are going to try to do something to help people in that regard. And it's an amazing opportunity for us to educate what we've done and what wells can do to reduce that price tag and make the project timely, doable, and manageable. you're talking about sometimes hundreds of thousands, millions of dollars to run water to a handful of homes outside of a small community. And as the Water Well Trust, which Margaret does in her spare time, it's another full-time job. She's had these examples all over the country, and we're saving 90%, 95% by going and drilling a well, or a well that serves multiple homes, as opposed to trying to run city water out to these places. So that's really going to come into focus. Another really interesting area for us is going to be working with Native Americans. The bill contains $3.4 billion over the next 5 years for the Indian Health Services, and to do wastewater and drinking water. And Margaret has already done one of these projects in New Mexico, and the profile of these are very, very rural places, often don't have electricity, do not have water, collect water with cisterns. Really the cost-effective and answer to many of the drinking water problems for Native Americans in the West and Southwest especially is going to be through the use of wells. They're not going to be building complex drinking water treatment systems that involve chemical treatment, full-time staff to manage them. We're going to be looking at really relying on wells to provide a lot of the quality, affordable drinking water that these communities are going to need. And just to put this in perspective, that $3 billion plus number is more than we've spent historically from the federal government's perspective annually for the whole nation. We're looking at a little over $1 billion a year for wastewater infrastructure, the same for drinking water infrastructure. Over the next 5 years, we're going to spend, $3+ billion on water and wastewater on really 1% of our population. But the needs there are acute, and wells and well systems are a big part of that solution. So when we do our fly-in, and knock on wood, COVID will be in check, and we will be able to have visits on Capitol Hill again and do all the meetings and spend time with members at the end of April. One of the areas we're gonna focus on beyond EPA and beyond USDA, who we've historically worked with, will be the Bureau of Indian Affairs. And we really need to let them know that we're a big part of the solution in this new area of investment, and really looking forward to that. And we'll be looking for members of the Water Systems Council from the West and to give us some insights on how best to engage. The EPA, USDA, they're doing the best they can to get that money out. Tying this back to politics, this is an election year. There's been a very large infrastructure bill passed, and there's going to be a big push between now and next November to get as much money out as possible. Again, this is a 5-year bill, but they are really working hard at all the agencies to cut the lag time so that the people who supported this legislation, whether it's the White House, Democrats, many Republicans on Capitol Hill, will have a good story to tell in November. So I think we will see real potential here coming to fruition in the spring. Other aspects of the bill that I would want to mention is the bill makes for the first time an enormous investment in rural broadband, and going to put $65 billion in there that will be leveraged with private sector money to make sure that, whether you're in West Virginia or upstate New York or rural Carolinas, you will not only hopefully have water to your house, you'll also have access to broadband. And with the remote working realities of the past 2 years of COVID, literally millions of Americans have left urban settings and are moving to more rural parts of the country. And as someone from a town of Cooperstown, New York, 1,700 with one stoplight in which everyone's on a well, it's a great quality of life. And I think, I know where I'm personally from, lots of land values and small homes and small farms have gone up significantly in value as the 9 million people in the New York metropolitan area are looking to have a second home, and now in many cases a first home in upstate New York. And that change in demographics is happening in a lot of parts of the country. Margaret and I were on with the New York well drilling community last week, and they were very busy. And a lot of it was drilling new wells for urban migrators to rural America. So I think broadband will just be another piece of that puzzle, and will probably contribute to a lot of well drilling, a lot of use of pumps, and all good for us. I just want to close talking about what's going to happen sort of politically and substantively here in DC over between now and next November, the second session of the 117th Congress. We're really going to see members looking to do things back home. So if you're a congressman, if you have a good story to tell about a pump system you're putting in or a community you're helping, let's try to get members of Congress out to see those projects, let them know about it. The substantive work that'll go on here will be a lot of hearings, probably for legislation that's going to happen next year. And one of those major things is the Farm Bill. Every 5 years, the US Congress does a Farm Bill. It's probably, like infrastructure, one of the handful of truly bipartisan things that gets done and has to get done, and it will get done next year. And a great deal of the funding to support wells and well systems in rural America that Margaret is really tapped into over the last 5 years with USDA comes through the Rural Utility Service and the rural funding programs for drinking water. So we will be heavily engaged with the members of the Senate Ag Committee. The chair is Senator Stabenow from Michigan, and the ranking member is a good friend of ours and former recipient of our Legislator of the Year, and so all around good guy, Senator John Bozeman, and he is very excited to work with us. And we're going to have some real opportunities to increase the investment of USDA in rural drinking water. So that's something legislatively, through hearings, through providing witnesses, testimony. Most of the members of both the House and Senate Ag Committee, if you're in the Senate and you're from a rural state, irrespective of party, you're on the Ag Committee, or you try to be, and the same in the House, irrespective of party. These are members of Congress that are very attuned to the water challenges, drinking water challenges in rural America. So that will be a big part of our efforts here. And we really need to make sure that EPA is helping educate these rural communities on the use of wells and well system as a really effective, cost-effective way to get quality drinking water to literally millions of Americans who currently don't have access. And, it seems whoever we meet with at EPA seems a little shocked when we tell them how many Americans don't have quality drinking water in their homes in rural America. And they always ask, usually Margaret and I, where do we get those numbers? They're like, they're your numbers. It's an opportunity. It's going to be exciting times. I hope the members of the Water Systems Council hopefully are going to be tuning into this, will have an ability, and we will be able to offer an opportunity to come to Washington in April. And I know Margaret has dates picked out, and we'll be circulating those. And we're really, really looking forward to seeing you here again. I look forward to seeing everyone in person. It's been too long.
Well, thank you very much, Jeff. There's so much exciting things going on in Washington, D.C. because of this bill, and also some work that we have to do on the farm bill. So I really appreciate the update. I'm sure everybody out there does, and we will continue to keep people posted as to what's going on as we work through this infrastructure bill and funding and getting more support for water well systems. So, okay, now we are going to move on to Jesse Richardson, our legal advisor. Jesse has a PowerPoint presentation he's going to share with you guys and talk about some important legal things that are going on that affect the water well industry. Jesse?
Okay, well, as Jeff said, I really wish I was there in person. Miss being in Annapolis with you all. Maybe I'm hoping that since I'm there on video, at least, that it'll bring my Baltimore Orioles some good luck, because I'm there in spirit. Since it's almost 20 degrees here in Morgantown, I decided to do the presentation out on the patio here in the front steps of the law school. I'm going to focus on 3 issues today. There are still a lot of issues going on across the country with water wells legally. We still are seeing mandatory hookup. We've got a lot of states who are really ratcheting up the regulation on private water wells. And particularly in California and on the West Coast, we're seeing a lot of different maneuvers by local and state governments to basically say that they own the groundwater. And that's important even for people in Maryland and Delaware, because it starts in California, it usually comes across to the East Coast. But I'm going to focus on 3 federal issues today, because they are the issues that are dominating with respect to groundwater. First, I'm going to talk about the recent United States Supreme Court decision in Mississippi versus Tennessee. Somehow I got that flipped on the PowerPoint slide, but this is a historic case involving groundwater battle between 2 states. Next, I'm going to talk about the issue that just never seems to go away, waters of the United States. And even though that mainly focuses on surface water, groundwater keeps coming up as an issue. And with the rule that the Biden administration recently published in the Federal Register, there are increasing questions about whether groundwater will be part of waters of the United States. And very recently, the United States Supreme Court indicated that they might be stepping into this debate again. And finally, I'm going to talk about the Maui County case, or groundwater as a conduit, or some people call it indirect discharges to waters of the United States. This is an issue that Water Systems Council has been following for a long time. We filed an amicus brief, or a friend of court brief, with the United States Supreme Court, and the National Groundwater Association joined us on that brief. The court has made their decision, and we're seeing the impacts of it in the lower courts now and in the Biden administration. So let's talk about these issues that are happening. First, Tennessee, or why do I keep saying that? Mississippi versus Tennessee. The first groundwater battle between states. We've had a lot of water wars involving surface water. This one involves groundwater. And here, Mississippi has filed a lawsuit, and this has been going on for about 10 years. Usually when two states are battling over interstate waters, one state will file for what we call equitable apportionment. And that asks the United States Supreme Court to divide those waters between the two states. Mississippi has not done that yet. Instead, Mississippi took a different strategy. The situation is that Memphis has sunk a number of water wells right along the Tennessee-Mississippi border, and they are pumping tens of millions of gallons of groundwater per day from these wells. Obviously, with wells that large and that close to the boundary, the cone of depression extends into Mississippi. So essentially, Mississippi comes to the court and says that Tennessee, Memphis in particular, is stealing our groundwater. They're using these high volume pumps and sucking the groundwater from beneath the state of Mississippi. And Mississippi says we own that groundwater and they're stealing it. That is really what they alleged is theft. And we don't want the court to divide the groundwater between the two states. We want the court to have Tennessee compensate us for the water that they've stolen. And we want the court to order Tennessee to stop taking our groundwater. Well, after several years of the special master taking evidence, the special master finally issued a report. That report suggested that the court should dismiss this case and allow Mississippi to file an equitable apportionment action. And very recently, the United States Supreme Court issued their opinion. And they declared that no, Mississippi, you do not own the groundwater beneath your state. This is an interstate aquifer, not just located under one state. And therefore, the court said, if it is indeed an interstate aquifer, if the water in that aquifer flows naturally between the two states, and if the actions of one state affects the portion of the water beneath the other state, then the only thing that you can do is ask this court for equitable apportionment. Now, the court also refused to grant leave to Mississippi to file that equitable apportionment action. I personally do not think that is significant. Mississippi has not yet asked for equitable apportionment. And in my view, if Mississippi wishes to get equitable apportionment, which they probably will at this point, then I think the court will allow them to at least put that forward. Now, there's been a lot of speculation since this decision. Many people think that this decision will encourage Tennessee and Mississippi to enter into a compact and agree how to allocate the water between the two states. I'm skeptical of that. There has not been a compact apportioning water between states in over 40 years. And in that time period, there have been numerous battles between states, most notably Florida versus Georgia. And in Florida versus Georgia, the United States Congress on 2 separate occasions basically told Florida and Georgia, do a compact, resolve this issue. And even though those 2 states continue to rack up huge attorney's bills, they refuse to enter into a compact. And I just don't see where Tennessee has any incentive to enter into a compact. So some other people have said that this is basically a signal from the court that states should pump, baby, pump that groundwater, because there may not be consequences for that. I plan to take some time over the next 18 months or so to really do a deep dive into this case and into this issue and try to forecast what the future is going to be for groundwater in the United States. It's going to be interesting, I think. This is a map of that aquifer. You can see that it does flow through 2 different states. Not a very good map, but that is a map. I'm a lawyer, so I'm not good at putting pictures into my presentations, but I'm trying to get better at it. The second issue that I want to talk about today is WOTUS. And there's a reason I have a picture of someone getting sick on a roller coaster here. I don't have to make this stuff up. The true stories are better. But over the past several years, we have seen the rule go back and forth, back and forth. In December of 2019, I'm trying to make sure I have my years straight here. In December of 2019, the Trump rule took effect. There were a number of lawsuits filed. The Trump administration definition of waters of the United States was narrower than what the Obama administration had defined waters of the United States. And I should back up a little bit. For those of you who don't deal with this every day, and you all deal with water every day, but not the legal issues. What does waters of the United States mean? Why is this important? Under the Clean Water Act, if you discharge pollutants into waters of the United States, you have to get a permit. Basically, the EPA and the Corps of Engineers has authority over waters of the United States. That concept of waters of the United States comes from the Clean Water Act definition of navigable waters. Navigable waters is defined as waters of the United States. Well, thanks a lot. That tells us a lot. And in the last 50 years or so, we have struggled to determine what is the reach of waters of the United States. Often the focus is wetlands, and wetlands that are adjacent to truly navigable waters. But groundwater has entered into the debate. And so we start with navigable waters. The court is now trying to figure out, how far does this go? Congress could act, but Congress hasn't been doing a lot lately except fighting. And so the question is, how far does the federal government's authority reach under the Commerce Clause? Certainly they have the ability to regulate navigable waters. How much beyond that? So in 2006, The court decided a case, Rapanos, and I'm going to get back to that case briefly. But that case came out 4-4-1. A lawyer's dream or a lawyer's nightmare, depending on how you look at it. The plurality opinion had a pretty narrow definition of navigable waters, which was basically it had to be either navigable or physically adjacent to navigable waters. The one vote, the 4-4-1, the one was Justice Kennedy, and he came up with a substantial nexus test. If the water has a substantial nexus to waters of the United States, then it can be regulated by the federal government. Well, that's pretty subjective, and nobody really knows what that means. So 2006 was when the roller coaster started. This Rapanos decision comes out, the EPA and the Corps try to figure out what does this mean and issue some guidance. Then the Obama administration said, we're going to step in, we're going to solve the problem, we're going to pass a definition of waters of the United States. It's fairly broad, but it expressly excludes groundwater. Groundwater is not waters of the United States. President Trump is elected. He promptly says, I'm getting rid of that Obama rule, and I'm going to pass the Trump rule, the Trump administration rule. Well, dozens of lawsuits were filed against the Obama rule. Dozens of lawsuits were filed against the Trump rule. When the dust settled in 2019, about half the states were under the Trump rule, about half the states under the Obama rule. Then President Trump was able to, or his administration was able to get rid of the Obama rule, and now all the states use the Trump rule. But then the lawsuits filtered through again, and the court said, we're not going to use the Trump rule anymore. We're going to go back to the old 1985 rule. Now President Biden's administration said, I'm going to solve the problem. And I think this is the 6th time that we've tried to come up with a definition. Maybe the 6th time is the charm. This rule was published. I believe the comment period recently expired by the time you watch this video. And the Biden rule is somewhere between the Trump rule and the Obama rule. But the concern is that the Obama rule, because of Maui County, which I'm going to talk about in a minute, in some footnotes, the Biden rule says, we're not going to exclude groundwater from the definition of waters of the United States because of this Maui County case. Sometimes groundwater can be involved in these discharges, so we're not really sure, so we're not going to exclude it. Now, the roller coaster story. A group of businesses, they got dizzy from the rule changing back and forth, and they filed a lawsuit in court and said, Judge, this has been a roller coaster of regulation. Please just put it back to the Trump rule so that we can have one rule and we can have a little certainty. And the court said no. So at this point, everybody is under the 1985 rule. Sometime in early 2022, sometime early this year, I anticipate that the Biden rule will become final, maybe. If it does, I will guarantee lots of lawsuits and the roller coaster will continue. Something happened just recently on January 25th. On January 25th, the United States Supreme Court, and this kind of surprised a lot of people, said we are going to hear the Sackett versus EPA case. This really, lawyers were all aflutter when this happened. The Sackett case involves a wetland in California, and the Ninth Circuit Court of Appeals. They applied that substantial nexus test that I talked about. And when the Sacketts appealed this case, they asked the court to say, re-examine the Rapanos case and go back to that case, and let's use the narrow definition from the 4 instead of this broad definition from the 1. Due to some pretty arcane legal rules, courts were saying that substantial nexus rule applied. The court said, we will hear the case, but they changed the question a little bit, and they said, what we're going to decide is whether the Ninth Circuit applied the correct test or not. That seems to be a distinction without a difference. It seems like the court is saying it's time to look at Rapanos again, and we now have basically a 6-3 conservative court. Since 2006, the makeup of the court has changed substantially. And so the court could well come down and say, we're going to redefine waters of the United States. Whether they're going to use that 4 justice opinion from Rapanos or not, we're not sure. This is really important for groundwater, because there's been at least one court who has used the substantial nexus test to say that groundwater is WOTUS, and therefore anything you put in the groundwater, you need to get a permit. If the court refocuses the definition of WOTUS onto surface waters, navigable waters, then that means that any consideration of groundwater being WOTUS, I think is gone. And I think the Biden administration might change that rule in that respect, or they might delay the rule to see what the Supreme Court of the United States says. But to muddy the waters a little bit here, Maui County case. Clean Water Act says that thou shalt not discharge a pollutant from a point source into navigable waters without a permit. The term discharge means an addition of a pollutant to navigable waters. Here's the question. Groundwater comes into play again. The question is, if a pollutant is put into the groundwater, that groundwater is hydrologically connected to a navigable water, and so the pollutant travels with the groundwater to the navigable water. Does the Clean Water Act apply? Or in other words, instead of a direct discharge from the pipe into the water, if the pollutant goes to the groundwater, then into the navigable water, does the EPA and the Corps have authority, and do they require a permit? Well, Water Systems Council felt like this was a really important issue. We filed a friend of court brief. There's a possibility that if you say that these indirect discharges are covered by the Clean Water Act, that water well contractors might have to get a Clean Water Act permit. I mean, we don't know. Well, we filed our friend of court brief. I got to attend the oral arguments. It was very exciting. And the court issued their opinion. And as the court seems apt to do lately, their opinion just caused more uncertainty, more lack of clarity, and the sales of aspirin and other headache remedies skyrocketed. The court declined to accept either side's argument and said, we're going to cut the baby in half, and we're going to say that it is a discharge for purposes of the Clean Water Act if it's fundamentally similar to a direct discharge. And they said, we're going to look at these factors. How long does it take the pollutant to get into the navigable water? What's the distance? What's the nature of the material traveled to? What's the extent that the pollutant is diluted or changed? The amount of pollutant that makes it into the water, the manner by or area in which the pollutant enters the water, and the degree to which the pollutant has maintained its identity. And they kind of said that the first two, time and distance, are usually going to be more important, but they also said, oh, by the way, these are not the only factors. There can be more factors. Well, the dissenting opinion was blistering and said, you basically made up a rule, and you made up a rule that nobody understands. So what we have now is a lot of uncertainty. And just to briefly, because this picture here that's on my PowerPoint slide is very apt. The EPA said we'll issue some guidance, and they issued some guidance that talked about these factors, added one additional factor. Between that time and now, a court has basically ignored that guidance. And then the Biden administration said, we revoked that guidance and we're going to do our own guidance. The roller coaster continues. The Maui County case was sent to a lower court. The court looked at the factors that the United States Supreme Court had put forth and decided that Maui County lost, that they need to get an MPDES permit. Maui County asked for a rehearing. They argued about the attorney's fees, but in the end, they decided not to appeal the case. There have been several other courts that have looked at this issue since the United States Supreme Court decided Maui County. Most of these cases have involved wastewater and wastewater systems. And I'll note here that interestingly enough, at the oral arguments, one thing that the justices talked about quite a bit, and it showed up in the dissenting opinion, they said, what about septic systems? If we say that you need a permit in this situation where a septic system pollutes navigable waters, does that homeowner need a permit under the Clean Water Act? And after these cases, after the United States Supreme Court decision, I can definitively give you a very clear $500 an hour answer. I have no idea. And neither does anybody else. There's a lot of uncertainty here. And let me circle back a little bit. All the time that Maui County was going on, everybody was very they stress the fact that this indirect discharge is in no way related to whether groundwater is waters of the United States. But remember what the Biden administration said in their definition of waters of the United States. They said, well, gosh, we're not going to exclude groundwater because under the Maui County case, indirect discharges may fall under the Clean Water Act. So it appears that this is a strategy to try to get groundwater under a different part of the Clean Water Act, one way or the other. And how this is all going to shake out, I don't really know at this point, and I don't think anybody does. Perhaps the United States will provide some guidance in the Sackett case. The United States Congress could step in and clarify everything by passing a law. I have zero confidence that that's going to happen. So I think that things are going to remain uncertain, and we're going to stay on that roller coaster. So my message to the Maryland-Delaware Association, you all are a great association. I think one of the models that I've seen in the United States. So keep up the good work. You can't rest. You have to continue to stay up on these issues, whether it's at the local level, the state level, or the federal level. Make sure that the voice of Maryland and Delaware water well contractors are heard. And I hope you all have a wonderful conference and show in Annapolis. I really wish that I could be there, and I am really looking forward to seeing you in 2023, if not before. I hope I see you before then. So everybody take care and be safe.
Well, thank you very much, Jesse. I think everybody understands why we need a legal watchdog like you for the water well industry. So we greatly appreciate you out there paying attention to what's going on and being able to explain it to us, the laymen that don't quite understand all of this. So thank you so much. The mission of the Water Well Trust is to promote and protect water well systems. And we do that with the help of Jeff Moore in Washington, D.C., and Jesse Richardson, who's out covering the entire United States legal issues. So thank you, gentlemen, very much from Water Systems Council for all the work that you do, and know that Water Systems Council will continue to be out there paying attention to what's going on for issues affecting the water well industry. Thank you, everyone.